Yes.
For listing of unlisted matter of a bail matter. The petitioner is a 19 years old boy, matter. He is saying.
No, you want to move an unlisted motion? What? Bail?
Bail.
Okay.
Ma'am, I beg to mention, I can not this matter will be taken next week.
Next week. What for it is listed today?
Admission.
Have you informed the other side?
Yes.
Okay. After a week.
Yeah, please. I beg to mention item number 13, 1. Today, council is unable to appear. That will be fixed on 31st August.
31st.
Yes, ma'am.
Okay. You are for the petitioner.
Yes, ma'am.
Your name?
B. Mandal, ma'am.
All right. On the prayer of Mr. B. Manna.
B. Mandal.
Mandal.
Mandal, yes.
You use the mic, please. On the
Mandal.
prayer of Mr. B. Mandal, learned counsel for the petitioner listed on 31st.
Yes.
Thank
you. Lord,
I beg to mention item number 26.
Yes.
I have already informed the other side.
Yeah.
Matter may be listed after 3 weeks. I'm on behalf of the petitioner.
All right. On the prayer of Mr.
B. Nyarus.
B. Nyarus, learned counsel for the petitioner on with the consent of the learned counsel for the respondents listed after 3 weeks.
3 weeks. Much obliged.
Section
302.
302. When? Call for the case diary fixing.
Fixing today is after 1 week.
Give a date. From which place?
This year.
Pasigat. Okay.
31%.
31. 31 is what day?
Thursday.
Thursday.
It should be on 4th
4th is
4th
what
of
day?
September. It's Monday.
4th of September. Okay, 4th of September.
Updated CD.
Updated CD.
Maybe
This is coming up for the first time.
No, this
No,
is
no.
for 5th time. That's it.
5th time. Rejected twice in session court. Rejected.
Why it is been listed in Mosam?
Third subsequent bail applications.
Or start
Successive bail applications.
successive bail application.
Before this honorable court.
Successive bail application coming up for the first time.
No.
No,
Okay,
for second time. This is third successive bail.
all right. 4th of September. 4th of September.
All
right.
right. Deeply obliged.
Yes.
My lord, this on health ground, my lord. 439 application.
Yes. What is to be done?
My lord, in fact, for the learned trial court, the CBI did not object to the medical checkup, but I don't know how the bail got to be rejected. Let my learned friend get instructions, my lord.
Section?
Section is 120B 406 409 420, read with 7, 8, 13 of the PC Act.
CD is not.
My lord.
When?
Thursday, my lord, in fact, before the learned trial court written
Call for the case diary fixing.
my lord, Thursday.
5th, my lord.
5th of September is the next date.
Please, my lord.
Yes.
My lord, here I have challenged the advertisement, my lord, dated 28/4/2023, my lord. My lord, person to my
But
lord.
I have not been able to understand. This writ petition was moved on 24th of
Yes, my lord.
July 2023 before this court.
Yes, sir. I saw 3 days.
The case was adjourned on your prayer to be listed after 3 days.
Yes, my lord.
Now, it has been listed thereafter today.
Yes, my lord. My lord, we have inquired, my lord, but there is a note of the, my lord, registry, my lord, to list the matter on after 24th. after
Hmm?
24th, my lord.
Hmm?
There is a note of the registry, my lord.
Yes,
Despite the honorable court's order, my lord, there is a note, my lord, saying that
Yes.
the matter will be listed after after 24, my lord.
no, you are wrong, Mr. Sakya. There is a note of the registry to list after 22nd August.
Yes, my lord.
How it can be when the order was,
Yes.
huh?
That was also we queried, my lord, but
So what is to be done?
my lord, may I humbly pray that, my lord, other connected matters, my lord, wherein the advertisement was challenged, my lord. The same advertisement, my lord has heard the matter in length, my lord, and the matter is, my lord, kept on CAB, my lord. So may I pray that, my lord, after the.
I, Mr. R. Sehgal, counsel for the petitioner. Mr. Mr. N. Ratan, London AAG, for which respondent?
1, 2, 3. 1, 2, and 3.
1, 2, and 3, and Anju,
I'm for respondent number 4.
for respondent 4.
My lord, 5 also, my lord.
Okay, and number 5. When this matter was listed on 24th July 2023, the writ petition was directed to be listed after 3 days on the request of Mr. R. Sehgal, London counsel for the petitioner. Full stop. Despite the opposite direction to list it after 3 days by the order dated 24/7/2023. There is a noting made by the registry in the order sheet dated 24/7/20 in the order sheet dated 24/7/2023 to list this writ petition after 22nd August 2023. Full stop. That is how this writ petition appears to have been listed after about 34 days. After about 30 days. Despite the order of this court to list this writ petition after 3 days from 24/7/2023. Deputy Registrar, in view of the above, Deputy Registrar Judicial is directed to put up a note as to how the how this repetition has been listed today, despite the direction of this court to list it after 3 days by the order dated 24/7/2023 and place the note before the registrar.
Please, my lord.
Yes,
Lord, here I'm challenging impugn order by which my service has been placed under dash known, my lord. Impugn order is, my lord, at page 23, my lord. Initially, what happened, my lord? I was terminated from service. Against that order, I approached before this court. This court, by the order dated, my lord, set aside and quashed my termination, and authority are directed to reinstate me in the service, my lord. I'll take my lord to the past impugn order, my lord, page 23.
23.
Yes, annexure 5. Mary, in compliance to the judgment and order dated 10/11/2022, passed by the Honorable Guwahati High Court, General Bench, Srimati Nada Dumi, who was working as a peon, DC Office 0, is hereby reinstated in her service, who has been placed under dice known with attendant disabilities under FR 1783, with effect from 28/5/2014 onwards by the order number so dated 25/8/2014 for her unauthorized absence from duty. Now, and shall be deemed under dice known status as was on 25/8/2014, my lord. So here I am aggrieved by this dice known, my lord. So I am debarred from attending the duties, my lord. Now, my lord, because of this order, my lord. And my lord, can you see, my lord, judgment and order, this court is, my lord, at page 15, my lord, annexure 2, my lord.
Just a moment. Yes,
Yes, my lord. Annexure 2, phase 15, my lord.
page 15.
Yes, my lord.
1/5.
1/5, my lord. It's the judgment order passed by this court
Hmm.
on 10/11/2022. My relevance paragraph would be, my lord. Start from page para 10, page number 19, man. And para 11 is the relevant one. Page 20.
Yes,
Those under the fact and circumstances case and upon the consideration, I am the consider view that the impugn order dated 24/4/2020 issued by Deputy Commissioner Law 0 by memo number so is not sustainable in law and accordingly same is set aside. And the state respondent are directed to reinstate the petitioner back into service. However, liberty is granted to the respondent authority to initiate press proceeding as may be permissible in law, if so advised. The entitlement or otherwise of the petitioner on her reinstatement is left for the decision by the competent authority in accordance with law. So though I have been reinstated, but my service in place under dice non, my lord. This FR 17A, my lord. That's only that can be imposed for the past, my lord. Past absence, my lord.
okay, let him take instruction. Will you notice?
My lord, since I have been reinstated, my lord, this dice non, placing under dice non may be stayed, my lord. And I may be allowed to join in the service, my lord. Otherwise, this dice non will be counted, my lord, as a break in service, my lord. Before issuing this dice non order, also, my lord, they should have issued notice, my lord, but that was also not done. Technically, my lord, they have tried to supersede the judgment law of this court, my lord.
Let us see 17A. You wanted to refer to 17A.
Yes, my lord. Part 17A, my lord. 17A,
You were terminated from service.
service, that was challenged, and this termination was set aside, my lord. And
Why you were terminated for unauthorized absence?
yes, my lord.
Disciplinary
2000
proceeding was drawn up.
Yes, my lord.
Disciplinary proceeding was drawn up.
No. Without drawing up the discipline proceedings, I was terminated, my lord. And this Dice Norm 2014 was also challenged before the court in IA, my lord, which in WPC, my lord, which were discussed in the present judgment order also, my lord.
Yes.
Yes, my lord. 17A3, my lord.
Seventeen,
Three.
three.
Yes, my lord. In case of individual employee remaining absent, unauthorized, or deserting the post, shall be deemed to cause an interruption or break in service of the employee unless otherwise decided by a competent authority for the purpose of leave, travel, concession, quasi-permanency, eligibility for appearing in the department examination for which a minimum period of the county service is required. For the purpose, rule extract include a general. So, my lord, these would apply only to the past absence, my lord. My past absence, my lord. They cannot impose this indefinite, like indefinite, my lord. This rationale will be counted as break in service. I am not able to get.
All right. Yes, what do you say?
My lordship, notice may be issued on this.
You should notice. Mr. K. Tari, one of counsel for the petitioner, and Ms. K. Wang, one government advocate representing the respondents. Issue notice, returnable in 2 weeks. As Ms. Wang, government advocate, has entered appearance and accepted for notice for all the respondents, no formal notice need be sent. Extra copy of the writ petition be served upon her during the course of the day. Having regard to the nature of issue raised in the writ petition, the respondents are directed to file counter affidavit positively within a period of 2 weeks. Full stop. If the respondent authorities are unable to file counter affidavit within a period of 2 weeks, an affidavit opposing the interim prayer made by the petitioner may be filed. Full stop. Once the counter affidavit is filed, an endeavor may be made to dispose of the writ petition itself on the returnable date also. If the writ petition remains, okay, also. If the writ petition cannot be disposed of on the returnable date for want of counter affidavit by the state, by the respondents, prayer for interim order made by the petitioner shall be considered on the returnable date.
Definitely.
Which date? After 2 weeks, September 20. All right, okay, returnable September 20. Don't say 2 weeks. Okay. Yes,
Lordship, here I am seeking direction from the respondent to frame recruitment rule in respect of the post of director tourism in terms of judgment and order dated 13/2/2020, 2002. Lordship, prior to 1995, Lordship, the tourism department under IPR department. It was separated in 1995, and the post of director was created in the year 2000. After creation of the post of director, IFS officer was appointed as a director, to which in the year 2001, the writ petition was filed.
this is not a transfer matter.
No. Lordship. Transfer is also there, but main issue is the recruitment rules.
Is it?
Yes, Lordship.
But the registry has indicated it to be a transfer matter.
Transfer is also there.
It is
Here
also there.
also there.
Sure. You are praying for what? Framing of the recruitment rule.
Recruitment rules and
For which post?
for the director of the tourism department. Lordship, may kindly come to page number 24.
This is a cadre post of APCS.
It was withdrawn.
Withdrawn. Then what happened?
Your Lordship, in the order of order dated 13/2/2002, Lordship, this honorable court has passed an order. Your Lordship may kindly come to page number 24. The operative paragraph will be paragraph 29.
29.
Yes.
At which page?
Page number 52.
52. Yes.
Mayor. Now it is necessary and important to note that despite order dated 11/10/2001 passed in this case above mentioned, government has not taken any steps till date to make regular appointment replacing such ad hoc appointment. More so, no RR have been framed till date. After creation of the post of substantive on 8/6/2001, though functioning of post started since 1995 and evident from the government's own affidavit, it seems that the state respondent had yet to sever the affectionate bonds with advocation. Since government has failed to take any necessary action to fill the post on regular basis till date, in terms of the observation made in order dated 11/10/2001, I do not feel inclined to approve the present impugn appointment on deputation of the respondent number 4, and accordingly, there were reasons as indicated above to interfere with such appointment. Consequently, the impugn order is hereby quashed. Since the impugn appointment is quashed, it is directed that government may initiate for framing the RR regulating the service condition of Department of Tourism, including the selection and appointment to the post of Director Tourism or the equivalent post in the Department of Tourism with a reasonable period, preferable within 6 months from the date of receipt of this order, and the necessary steps to be taken to fill up the post on regular basis. It is further made clear that till the regular appointment, the state post, the government may consider to fill up the present vacant post in question by taking option from eligible officer from the APCS cadre or any other department holding equivalent post with equal pay scale of the present post of Director Tourism. This direction is made taking into consideration the amendment made in the state respondent in paragraph 6 of their affidavit as already noticed here in above. Lordship, here it's clearly said that ad hoc appointment should be stopped, Your Lordship, and recruitment rules should be made within 6 months. Now it's been more than 21 years. The still recruitment rule has not been framed. And now what happened, Your Lordship? Deputy Commissioner Tawang has been appointed as Director Tourism on deputation. It has been, the post of director has been vacant. So
Then who is the Deputy Commissioner in town? Same person.
no,
Okay. Who appears for the state? For all?
No, my lord. There is a standing council for
tourism.
tourism. Mr. N. Pada.
Who issue notice?
Yes, ma'am.
Till Your Lordship, this the posting of the director which has been posted on deputation may be stayed. Otherwise, if this continues, Lordship,
You have not argued on that. You have argued for recruitment rule, framing of recruitment rule.
it's in the environment. We have made the prayer also. I have made the prayer also, Lordship.
So you have to argue on that point. I have
Yes,
not heard you.
I'll come to that, Lordship.
Yeah.
Lordship, he has been deputed as a director. It has been vacant for some time.
Who has been deputed as a,
The order is in,
which respondent? Have you made him a party? Mr. Getso,
Lordship.
notice 4 weeks. Pada for 2 and 3. Ratan for 1. Yes.
All right.
My lordship,
Yes.
lordship, some time may be given for filing of rejoinder affidavits.
Revision, how much time?
2 weeks, lordship.
L-Baum press for it is granted 2 weeks time to file this and the listed after 3 weeks. Yes.
May it please your lordship.
Come.
The question of a complaint case,
Uh,
which was moved before this on report, my learned friend appeared. And the last time he says some instruction, whether he have received the instruction, that's very important.
Have you received?
So far, my lord, I haven't received my lord, the instruction from the my lord, department, my lord. In fact, communication has already been made.
Relieving me, you?
My lord.
I have not followed.
No, my lord, so far I haven't received my lord, the instruction.
You have not received?
Not received instruction, my lord.
Okay, what instruction you are supposed to
My
receive?
lord, the instruction regarding my lord, this proceeding. That basically, my lord, criminal complaint was filed by the my lord, the Union of India. And that has been registered and the trial was also going on, my lord.
Ah.
In the meantime, my lord, this is to my lord, the criminal petition has been filed for quashing of the proceedings of the my lord, criminal case, man. And in that case, my lord, the sum and substance, my lord, is spread for. Is my lord, basically, my lord, that two proceeding cannot be possible is because the my lord, this has already been taken into consideration by the my lord, the authorities, my lord,
State licensing authority already
license
has
authorities, my lord.
taken an action.
And the my lord, so therefore,
But there appears to be no order for,
I'm sorry.
there appears to be no order for receiving any instruction by him?
No, he argued, he said before the court
Okay,
last time, that's what.
then you get the instruction tomorrow? Since you have said,
my lord.
Last time he said,
ah,
but that's a very simple point here, my lord.
ah,
That's a, to either you take a administrative action or a prosecution. Administrative action, what they have done, my lord, a general order was issued by the licensing, central licensing authority in different district to collect the samples of medicine. So it was collected. It is a pressure tablet which was collected. It was laboratory, it was tested. After laboratory, it was tested, it was found two tests, one is dissolution and one is active content. Dissolution was not as per the limit. So accordingly, it goes against the petitioner. Now, similarly, my lord, situated at same tablet, same batch number, also was tested in the laboratory of the, or before at Silchar, that's a regional laboratory, it was found in order. Now, my lord, there are two ways. One is either you take an administrative action or a prosecution. Administrative action was taken by licensing authority, said, don't repeat near future. We have also taken given an undertaking, which is part of this petition, and we have already said, yes, action, we will take precautionary measure. And my lord, on this point, my lord, that was the administrative action was closed. Now, if administrative action was closed, there is no question of a prosecution, my lord. When the complaint was filed, my lord, they have suppressed the material fact. And when it was forwarded, my lord, the letter of prosecution itself says either you take administrative or your prosecution has to be lodged. So now, my lord,
perhaps on that point, he was
yes,
supposed
that's
to.
why maybe. my
See,
lord.
since there is a stay order operating.
Yes, I have
You,
absolutely no
you
problem.
take instruction.
Hello.
Since, huh? All right.
Yes.
When?
This I'm,
No, not necessarily tomorrow, as per your
After 4
convenience.
weeks,
You
so
take it.
after 4 weeks, after
When? Mr. G. Senate Council.
28, my lord.
Petitioner, 20,
8 September, my lord.
20,
8 September, my lord.
8th September.
After 4 weeks, my lord.
And Ms. M. Kato, Lamed DSGY, who pressed for listing the matter on 28th of September, he says. We'll say 28th of September.
My lord, subject to the convenience on the part of the senior council is coming from Guwahati. my lord.
He's saying 20.
if it is not inconvenient to your lordship and my learned friend, came on 3rd of October.
12th of October.
3rd of October.
3rd of October.
Third.
My lord.
Okay. 3rd of October to enable him to receive instruction. List accordingly.
Interim order,
Interim order pass earlier shall continue till the next date of listing.
I'm deeply obliged.
Deeply obliged.
Item number? Oh, yes.
The transfer matter, my lord. The lordship deems it,
Transfer letter?
yes,
Hmm.
modification without the sign.
Why it has been listed today?
Come for admission, my lord, admission.
So what is to be done? Will dispose, can you dispose it of?
Yes, ma'am.
Then, yes,
Lordship may kindly.
all of you are for disposal.
Yes, my lord.
Okay.
I would not, my lord, but they are insisting. There is a stay order, my lord.
Huh?
Stay order is there.
The stay order is there. Oh, so
It's a
that's,
small matter, my lord. This can be disposed this way or that way, my lord. Respondent number 4 is again not represented.
respondent number 4 is not represented.
Yes. Yeah, no, that.
Then what happens?
Anyways, he's not going to be affected, my lord.
Oh, he is not going to be.
He will be
affected.
affected, obviously he will be affected. He's not, he has not filed his affidavit also. There is another thing,
Which is the impugned order?
impugned order is page 29.
29.
Yes.
12 June.
Yes,
You are at serial number 2,
three,
3.
yes. So the serial number three comes in,
Allow to
three comes in my place. Serial number two,
serial number 2 comes in your place.
yes. So if your lordship interface, obviously,
He is R4.
yes.
How he will not be affected, Ratan?
Well, in fact, he did not even comply with the earlier one, my lord. I think he's happy either to be, to remain posted at Alo or at Pangin.
No, he said, hello, I am at Pagin in terms of stay order.
That I'll try to demonstrate, my lord.
Huh?
That I will try to demonstrate why he is not coming.
Okay. Which transfer order was modified? 15-6? No, not 15-6.
30 May,
35.
35.
35 was modified.
Page 26.
Page 26.
Before that, my lord, if your lordship takes it up for disposal, I will place my case from first.
Huh?
If your lordship deems it that it will dispose, then I will place it for
Just a minute. 30 May.
30 May, page 26.
Here is head number 3.
Yes, ma'am.
Allo to
To
Panging.
Yes.
Then who comes in Allo?
Serial number 2.
Serial number 2 comes in Allo.
Yes, respondent number 4.
Panging is also within Allo circle. No, Bene circle. Bene is a circle, I think.
Yes,
No.
Bene is a circle.
And Allo as well as Panging is under Bene circle. Is it the case?
It appears to my lord, there's one chief engineer, they are all in the same circle that I'm aware of.
Huh?
They are under the same chief engineer. But
Huh? No, before chief engineer, circle will come, chief. Huh?
They are all superintending engineers, my lord.
Well, Alo circle is different and Pangin circle is also different. And the chief engineer of the border circle is at Tejuman.
Huh?
Same division.
Namsaiman.
Same division.
So Alo is, Bene is within Alo and the Pangin is the Siang district, only Siang district.
Same division. I think.
Now, where this petitioner was working?
I was in Bene.
Bene. You
Pangin
have
is a different circle. I think.
You have been described in 30 May 2023
Yes,
as working at Allo, Bene, PHE and WS circle.
yes,
Is not it?
yes. Posted to PHEWS circle Pangin, so different circle.
PHE and WS circle means
Superintendent-
Panging circle.
Yes, Pangin sir.
Okay. Earlier you were in Allo circle.
Bene circle, yes.
Oh, Bene circle.
Yes.
Allo doesn't have a circle.
It is, office is at Bene, that's why they say Alo Bene circle. Office itself is located at Bene. It's
Office
near to
is-
Alo. The office of the superintendent engineer is located at Bene.
So you were there in Bene.
Yes.
Why this Allo? Allo has been put in?
Then I'm not very sure, my learned friend.
Alo town. But Bene is the division place where the office is.
See, it is creating little confusion. Bene is a circle, is not it?
Yes.
Bene is a PHC circle. Panging has also circle.
Right.
Does Alo is a circle, PHC circle? No.
No, man.
Okay. So he was there at Bene,
Yes,
posted at Bene,
Bene, man.
within Bene circle.
Yes.
Then why this Alo business?
Bene is within Alo, Malan. Therefore, just to put Malan, that circle, Malan, district name Alo has been given.
Okay.
It is
All right.
West Siang district, Alo, man.
Okay. Then we can refer it as a Bene.
Yes, Bene circle.
Okay, Bene. How many years you are there in Bene?
More than 5 years.
Okay, then you sent to Panging.
Fine.
Vacant due to 30th May
13th May.
and then 12 June.
Yes.
12 June you have been again?
I am now, my lord, sent to the sanitation state coordinator, SPMG.
And in your place,
This respondent number 5 has suddenly cropped up.
Oyuk Padung.
No, man. Regam Bobo,
Oh,
who was not there in the earlier transfer.
where was he? He was
He was
earlier?
there. Yeah.
Okay, coordinator,
Yes,
where you are now supposed to go.
yes.
He was there for how long?
That I am not aware.
You are for respondent of five.
Respondent number 5, man.
You were there for how long?
More than Malan 3 years, man.
2 years. Then he has to explain the reason, that's why, that's all.
That is the Malan only core issue, man.
Ah,
The
Before
person
that,
qualification,
Malan-
how it is being.
Because they are taking a stand that it was never affected in all this. Earlier, I was,
never?
this transfer order was never affected, all this stand they have taken. But
Okay.
I had joined, I had taken charge. In fact, much earlier,
Ah.
I had additional charge of that place.
And what else?
That's
What?
it.
That's all.
I had additional charge of that place. If your lordship had paid 22, my lord.
22 of the requisition.
Yes, ma'am. In view of the retirement of Sri Tamuli Tako SC PHE Circle Pangin, on attaining superannuation on 30th April 2023 until the posting of reliever, Sri Sasensas SC PHE Circle Alo, Bene is directed to take over charges of SC PHE Circle in addition to his normal charges. So I take over charge at page 23. First of May. Then the 30th May order came. By that time, I was already there, having taken charge. There was no question of again taking charge from anybody because this person is already superannuated. And in charge of the 30th order, I hand over charge at page 27.
You were there before you were transferred there,
Yes, additional charge
additional charge.
on account of superannuation of the incumbent there.
Hmm. Any other reason?
No, absolutely no reason, man.
This is the only reason. That you have not taken charge.
My lord, in the affidavit, yes, they have said it has not been given effect to.
Hmm.
Yes, that is the only reason.
Yes,
My lord will kindly see page 24, my lord.
24 of writ petition.
Sorry, my lord. Page 22.
Writ petition.
Yes, my lord.
Ah,
NHA 1.
yes.
My lord, this is, may I read, my lord?
Hmm.
In view of the retirement of Sri Tamuli Tako, SCP PHE Circle Pangin on attaining superannuation on 30th April 2023 and till the posting of reliever Sri Tuva SCPHE Circle Alo Bene is directed to take over charges of the SCPHE Pangin Circle in addition to his normal charges till the posting of reliever, my lord. And this was issued by the chief engineer. Well, transfer and posting of SCs, these are by the commissioners, my lord.
Hmm?
Commissioners.
Hmm.
This is an internal arrangement by the chief engineer because the earlier incumbent Sri Tamuli Tako was to superannuate on 30th of April. Pursuant to this, the petitioner has taken charge. And this order itself says till this was not a regular transfer, my lord.
Yes.
Now, on at page 24. Sorry, my lord. I'll directly take to page 26, my lord. This is the first transfer order issued by the secretary, my lord. Now, in the interest of public service, the governor of Arunachal Pradesh is pleased to transfer posting of the under mentioned group A officers, so and so, so and so. Here, my lord, Tony Ete, Alo from Alo division to Teju PHC circle, SSC, my lord. Then Oyuk Padung, the respondent number 5. From Teju PHC circle to PHC circle, Alo, Bene. Then petitioner. My lord, this was on 30th of May. 30th of May. Now, if my lord comes to our affidavit, my lord. My lord, we have annexed the note sheets, how the this transfer process. At page 13, this is the note sheet, my lord. Annexure 5. Initially, in short, my lord, initially there was a move for promotion of one Sri Tony Ete and posting him at Teju. And therefore, these two other officers, the respondent number 5 and the petitioner, they also, 4 and the petitioner, their transfer came to be affected also because of his promotion. Now this, as soon as this promotion, if my lord sees at page 14, this was the recommendation of the minister, my lord. The supervision of Sri ACPH Pangin Circle, Mr. Tamuli Tako has created a vacancy. Therefore, the following transfer and posting is proposed. Tony Ete, in charge, AC Teju PH Circle, ERO Padung, AC Teju, AC Alo Bene PH Circle, then ER Tubangu petitioner, AC Pangin Circle. This was approved, this was put up by the minister. Then this was approved. Now, after my lord, if my lord will come, the order was issued on because this was approved by the Honorable Chief Minister. It was the order was first transfer order was passed on 30th May. Then at page 16, my lord will see. 30th May, the order was passed, transfer order first. Then the minister calls back the file, madam. Immediately on 8th of June, madam. By this time, there was no any transfer, any compliance of the transfer order. My lord will see. None of them, all these 3 officers, they did not comply. Handing taking charges was not done. Then the minister again proposed that the serial number 1, Tony Ete, in charge as it is. Then O Padung AC Teju to AC Pangin. Initially, he was from Teju to Bene. But by this, there was a slight modification by the minister from AC Teju to AC Pangin. And Engineer Tubangu AC Bene is proposed as AC Alo. The petitioner was proposed to be retained at Alo, where he was, because he was holding the additional charge of ACPH at Pangin. Now, this was proposed by the Honorable Minister, madam. Then when it went up to the level of the Honorable Chief Minister, serial number 1 and 2 was approved, but however, in place of the petitioner, he was instead of being retained at Alo, he was transferred to AC sanitation, my lord. Now, my lord, this is the file nothing, this is whether there is any malafide or not, that I will not argue, my lord. What actually if my lord says, after this approval was done, then just when the order was supposed to be issued, then the handing taking is done in the same day. My lord will see.
This writ petition can wait.
My lord,
This writ petition can wait.
my lord may dispose of this in this way,
I-
this way order.
I was just, the court was just trying to find out whether the government also has a prima facie case.
My lord, wow, here only, if my lord permits, my lord, only three propositions of law. My lord is, the petitioner is on the proposition that once a transfer order is issued in public interest, the subsequent modification should be with reasons, my lord.
Hmm.
My lord, and we, the government, we are saying that the petitioner transfer is an incidence of service and petitioner cannot, as a matter of right, claim to remain at one place of posting. My lord.
Hmm.
And secondly, my lord, the government has a power to review. Now, my lord will decide whether this proposition, the proposition which the petitioner is urging, vis-a-vis the proposition the government is urging, my lord. Here, what is there? Yes, petitioners, there is a settled position that once a transfer order is issued, subsequent modification should be with reasons, provided also for the, my lord, that the transfer order which has been modified has been complied with, and because of the subsequent modification, there is hardship faced by the petitioners. Here, transfer order, they are urging that it is without any order, any reasons, my lord. However, that transfer order itself was never complied before the modification order came, my lord. My lord will just assume a situation. Today, an order was passed and order issued, a transfer order issued. Immediately, if the government realizes, no, instead of this doing this, we should modify it. Immediately, the very next day, before the transfer order is complied, or any party moves in person, whether that incumbent, they can, as a matter of right, say that no, once it was issued in transfer order, the very modification, the subsequent modification immediately is also should be with reasons, and it cannot stand without they actually facing any hardship, my lord, any prejudice, my lord. My lord will decide on this. Here is a case. The cases which for which the proposition that the subsequent modification order should be with reasons, in those cases, there has been a compliance with the transfer order, first transfer orders, my lord. Then the subsequent modifications.
And how this respondent number 4 will not be affected?
My lord, that's why he was happy. My lord will see that he was happy either to remain at Pangin or at Bene, my lord.
That's why he will not be affected.
He was happy. My lord will see from no, my lord, what he's still happy because when from the first
Had Mr. D. Bangla, Council for the Petitioner, Mr. M. Ratan Lanet, AAG for R123 and Mr. M. Gata for R5. Since the respondent number
My lord will see, my lord.
4 is yet to be served, listed after.
my lord, they have already
Yes.
entered appearance, my lord.
Who?
Opada already entered appearance and has been not representing.
Where is Opada? Opada was here. Oh,
On
no,
many
no.
occasions, he is
Okay.
not representing, my lord. Just because That's why exactly, my lord, what I'm saying, he's
No, no.
least interested.
O Pada has filed Wakalatnama.
Yes, ma'am. Earlier, he has taken time to file affidavit also. He has not filed, my lord. He has not appeared.
But office note says neither Wakalatnama nor counter affidavit
My
filed.
lord will kindly see other orders, my lord, initial orders, my lord.
On several occasions, my lord, council.
Not several, last occasion on.
On the last occasion.
Not several. occasion. Let's
Uh,
make some-
which date?
This was on.
My lord,
28/6.
Huh?
28/6, my lord.
28/6.
My lord.
No.
And then thereafter, I think also, my lord.
Oh, yes, 28/6.
That's why I was.
No,
I
see,
think 27.
on that day. 27?
7 was the order where. Mr.
27/7.
Pada was not present. 27/7. No, Ganda sir.
My lord, if I may be allowed, my
No,
lord. He has appeared.
no, it is like this. On 28/6, he appeared.
Yes.
Pada appeared. And he submitted that he will be filing his Wakalatnama for respondent of 4 as well as counter affidavit. Thereafter, he has not taken any steps, neither Wakalatnama filed nor counter affidavit filed. That is the position.
My
So therefore, we cannot say that respondent of
My
4 is legally represented.
My lord,
That is why there is
in
a,
any case,
No,
that the presumption is that respondent number 5 has the notice. Since he was, when a council was to be representing him.
see, we don't know what is going on between Mr. Pada and the respondent number 4. They are not before him.
My lord,
before
that's
us.
why if my lord permits, why? Because there is a connivance between the private respondent and the petitioner.
Okay. For and the
Personal
petitioner.
knowledge.
No, there is a connivance because that's why I'm saying that because he was happy, the private respondent Padung was happy either to remain at Bene or at Pangin, my lord.
What is the material to show that there
My
is a
lord,
connivance between?
I will show, my lord. That's why, if my lord kindly, please,
No,
Allows
allows
me,
you
my lord.
getting desperate and transfer, but I don't understand.
otherwise there is
You are now.
there is a stay order, my lord. Because of this time and again, they have been asking. Otherwise also, my lord, this way or that way, my lord, let it be disposed of. My lord will see. The move for subsequent modification was initiated on 6th. Initial transfer order was on 30th of May. On 6th, the move was done, 6th of June, my lord. They did not comply with that move. They were happy waiting. If the petitioner remains at Ano and the private respondent, Mr. Padung, remains at Pangin.
Hard. From the record, it appears that when this matter was listed on 28/6/2023, Mr. O. Pada had entered appearance on behalf of respondent number 4, on which date he had submitted that he would be filing Wakalatnama as well as the counter affidavit on behalf of respondent number 4. Full stop. Thereafter, in none of the proceedings, in none of the subsequent proceedings, Mr. Pada has either filed Wakalatnama or counter affidavit on behalf of respondent number 4. Full stop. In view of the above, listed again after 2 weeks by showing the name of O. Pada in the cause list as a counsel representing the respondent number 4. We'll find out from him What is the
My lord,
position?
that was the my lord,
order.
on the last occasion, my lord, that was my submission, my lord.
Ah.
This call was of the opinion that my lord, if he does not want to file affidavit or he doesn't want to take any steps, my lord, we cannot, my lord, they imposed and the force upon him, my lord. Of
Ah.
course, that has been not taken into consideration and reflected in the order sheet, my lord. My lord, however, my lord, on the time and again, my lord, non-appearance on the part of the my lord, the council for the respondent number 4. My lord, this matter is being, my lord, not taken into consideration, my lord. So therefore, my lord, at this stage, my lord, I am the ultimate sufferer. My lord, my lord,
See,
on 11, my lord, he did not appear, 27 and 20, on 18, my lord, on 23 also,
see,
my lord,
Mr. Kato,
my lord.
the respondent number 4 in any case has to be served.
My lord, once
But
the council has
see,
represented on behalf of
That's
him,
why, so there are two ways. Mr. Pada may not have appeared because his name is not shown. And how can his name be shown?
my lord,
Because he has not filed Vakalatnama. So we don't know what
my lord, this is the
transpired
techniques.
between the respondent number 4 and
My lord, it is the tactics done by them, my lord, is because my lord, the learned Asia has rightly pointed out. My lord, only because of these reasons, my lord, the matter is, my lord, how long I'm asking myself question.
all right.
My lord, how
just-
long he can, my lord, we can wait for him to come, my lord. That is the my lord one. Now, my lord, my lord, the interim order was passed on 20th June, my lord, 20th June. And even after my join, my lord. My lord, if my lord perused my affidavit, my lord may kindly peruse my affidavit. I joined on the my lord the 14th, my lord, June. Thereafter, my lord, my lord, I'm serving there. My lord, I'm now interim order, on operation of the interim order, my lord. I'm nowhere, my lord. Even after release from my lord, where I was. So therefore, my lord, it is my lord, my lord, some kind of urgency.
My lord will kindly see the pending taking over charge between the private respondent and petitioners and all done on one single day. On 12th, at handing over charge at Teju on 12th, taking over charge at Pangin on 12th. my lord.
Without release order, my lord. There is no release order from the my lord, the early place of posting, my lord. So even after my join, my lord, this my lord, the impure order, my lord, the impure order has been stayed. So therefore, my lord, I am my lord, seriously suffered.
Dusty was also taken on respondent number 4.
My lord.
Dusty service received Dusty on the. Was there a direction to sub notice by Dusty on respondent number 4?
I'm sorry, my lord, I still,
My lord, once the council appeared, my lord,
yes.
even
yes.
we personally, my lord,
On the first day there was. Appears.
and personally, we informed the council
20
for the my lord, private
20
respondent number
days.
4 also, my lord, on the several occasions, my lord.
Okay. Have you served notice by Dusty?
Must have, my lord, but I have not filed the affidavit because
Okay.
Mr. Pada appeared once, that's why. Must have.
Have you filed affidavit
No,
regarding Dusty service?
Mr. Pada appeared, that's why.
Okay, then you write further. Since there was a direction to serve notice upon respondent number 4 by Dusty by the order dated 26/2023. And office note dated 22/6/2023 also indicates that Dusty service, Dusty on behalf of respondent number 4 was also received by Margaret Dozy is along with you.
Yes.
Was received by Mr. Margaret Dozy, London Council for the petitioner on 22/6/2023. The petitioner shall also file an affidavit showing the proof of justice service effected on respondent number 4 within a week. List it after 2 weeks.
My lord, 1 week, my lord.
Huh?
After 1 week, my lord. As I pointed out, my lord, from 2000, my lord, the 20th,
Okay,
June.
okay, after a week.
after a week, my
Then
lord.
you also file
My lord.
within a week.
Yes,
Interim order.
Interim order pass, yes, sir, continue till the next list.
my lord, in second item, my lord, that has been filed by my lord, the criminal, my lord, the
This
petition.
order will be in item number 10, huh? In 11, list it along with 10. Yes.
Hello. Before submits my note. And I will given another 2 weeks or 3 weeks time to file a legal matter.
The lordship, this situation is like that petitioner or final year student.
Hmm.
So this delay of this case that with the right of this petitioner lordship.
Hmm?
The delay of this case that with the right of the petitioner lordship, because they are third year.
Delay of this case will deprive the right of the petitioner.
Yes,
What is the matter about?
lordship, this is as per the Supreme Court direction that student representation election is mandatory, lordship.
Election.
Yes, lordship, it is mandatory. Now NIT, National Institute of Technology, Jote, they have passed one.
If the student election is not immediately conducted, what
No, lordship, yes.
hardship or prejudice you will suffer immediately?
Lordship, that as per that tenure, that election is conducted on fixed year. Now the lords, this petitioner are third year student, lordship, and by this delaying this case, they will once they pass out.
Because of non-holding of the students' election
Yes.
and constitution of the students' union, does the academic interest of the petitioners suffer in any manner?
Lordship says,
Immediately. If you are facing specific problems, if the petitioners are suffering from specific hardship because of the non-holding of election, we will take care of that.
Lordship,
What is that? What is that?
Lordship, then 1 week will be given. Lordship, 4 weeks has been already given for the file because respondent are already in capital complex.
Okay, we'll give 2 weeks time.
Lordship.
Okay. No, see, that is why the court is asking. What is the hardship that the petitioner is facing immediately, so that can be taken care of? But you are not telling anything.
Just
Does your academic interest suffers? Is there any impediment in writing your exams? Other holding of the regular classes? No, nothing like that. We give them 2 weeks time.
In fact, in this case, madam, by a notification of the institute, madam, a student association of NIT was formed, madam, by the authorities, madam, and accordingly, madam, elections were also held, madam, and the petitioners are secretaries, presidents, madam, and they, after the election, madam, they represented before the madam authority to change the madam name of the association into madam as a student union of National Institute of Technology with different purposes, madam.
Anyway, you file affidavit.
Madam.
Mr. G. Kato. learned counsel for the petitioners, and Mr. R. Saikel, learned standing counsel for the NIT, who pressed for and is granted further 2 weeks time to file counter affidavit. List it after 2 weeks.
Your Lordship, CD was called for. And Your Lordship, this case was registered under 174 for unnatural death. And the FIR has not been registered yet, Your Lordship. Therefore, Your Lordship, there exists no apprehension, Your Lordship, at this stage. Because FIR has not been registered, Your Lordship.
Okay. Then we dismiss.
What's it? Though FIR has not been registered yet, but as and when it is registered, the apprehension.
Can anybody be arrested without registering a case?
That's the not much.
Mr. M. Ete, learned counsel for the petitioner. Mr. T. Ete, learned APP for the state. This is an application under section 438 of the CRPC for granting pre-arrest bail to the applicant, namely Sri Kenley Nyorak, who apprehends arrest in connection with BSS/PS/GDE, case number 10. Case number 10, dated 19/6/2023, and UD case number 02/2023 under section 174 CRPC, arising out of FIR dated 19/6/2023. Correct?
Yes, Your Lordship.
Okay. Full stop. When this matter was taken up on 23/6/2023, while granting the applicant a privilege of interim pre-arrest bail, this court had called for the case diary. Full stop. Mr. Ete, learned APP on instruction, is not it?
Yeah, I have the case diary. Your
Oh, you have the case
Yes,
diary?
yes.
Okay. On the basis of the case diary received, has submitted that no case has been registered.
Yes, so far as cognizable offense is concerned, Your Lordship,
Okay.
only 174 is there.
Okay. Submits that on the basis of the case that you received, submits that no case,
Has been registered in.
Also because there is nothing in.
no case has so far been registered of any cognizable offense.
And non-bailable.
Huh?
And repeat, Your Lordship, no, cognizable
sir.
and non-bailable.
No cognizable as stop, non-available
Yes.
offense. Full stop. Since no arrest can be made without registration of a case pertaining to non-bailable offense. The petitioner in the instant case cannot have any apprehension
Yes.
of any arrest made in connection with BSA, etc. And UD case number, etc. In view of this anticipated bail application stands dismissed as not maintainable.
Yes. Obliged, Your Lordship.
The victim complainant is in adultery with this, the wife of the alleged accused person. Thereafter, this has been registered. Case diary was called for. My lord will kindly come to the FIR,
Yes,
page 12.
page 12.
Yes. With due respect
Yes.
and humble submission that I have been brutally attacked by Sri so and so along with his gang members. But my lord, there is no gang member. On 28/2023 at so and so resort, Doimuk around 10:45 AM. Further, it is pertinent to mention herein that they were pre-planned to attack me as some years back. My lord will mark this some years back. I have a document to corroborate it. Forcefully making unnecessary allegation that I was having affair with his wife, so and so without any proof. And that is the reason why today they brutally attack me with deadly weapons like iron rods, stones, wooden stick. And thereafter, I was almost unconscious state and found that I got seriously inflicted or injury by the weapons they use, like left side of my
Do you have
ears.
case diary with you? Any materials against him?
Lordship, in the case study, Lordship, the case, this investigation is still pending, Lordship, because the accomplices, there are three other people was there, Lordship. Their statement has to be recorded.
My lord,
And
They-
the injury report is also there. Lordship.
my lord, two of,
Injury report is also there.
Injury report is there.
Yes,
Yes.
Lordship.
my lord, two of them,
What kind of injury? Grievous.
Yes, Lordship, grievous also as well as simple also, because grievous Lordship, because this human bite is there also in the ear.
Huh?
Ear Lordship, this accused Lordship, during that fight Lordship, he very badly. One of the
Ear-
areas.
Ear was,
the air was
ear was beaten,
beaten up.
beaten by,
Hit Lordship.
so like Tama, you either tomorrow or day after tomorrow. Yeah? Tomorrow or day after tomorrow. Tama is doing the case day after tomorrow.
The same matter.
Okay. No, no, no.
Okay, okay. Day after. my lord.
Day after, okay.
Day
Same order,
Yeah.
Tara and El Hage. Pursuant to earlier order, case there has been produced on the prayer of Mr. Tara, listed on 30. 30, case diary shall be written by Leonard APB, which shall be produced on next.
This is the funniest case.
Looks like.
Like,
Understand?
May I please address?
Yes.
Here the victim
What is the section?
is section 366 and section 6 of POCSO Act.
Have you informed the PP?
Yes,
Okay.
now first.
Dated 17/8/2023, my lord.
Huh?
As per office note dated 17/8/2023, my lord, the
Yes.
newly implemented respondent on 15. This is not found.
Yes.
In this case, my lord, I may be allowed to take place step upon respondent on 15
Hmm.
after correction of the address, my lord.
Mr. Margedi, you are appearing for?
On behalf of standing counsel to him.
Mr. Margedi will only counsel for the petitioner. Praise for and is granted how much time? To take steps?
3 days, my lord.
Huh?
I will take it within 3 days, my lord.
Have you ascertained the correct address? No.
No, madam.
Then,
I will do it.
okay. Press for any is granted 1 week time to take fresh steps for service of notice upon respondent number 15. After ascertaining the correct address
Yes.
of the respondent number 15. Full stop. You begin this sentence by in view of the office note dated 25/8/2023. Huh? List it after 4 weeks.
All right.
My
Yes.
lord. The SLP in Manaksota Club is due listing on this 5th, September 5th. These content may be list after 5th. Fifth. My lord, this is the last of the Supreme Court.
Okay. Which order has been challenged? Which judgment has been challenged in the SLP?
Writ appeal in Manaksota Club,
Where is that? Page number?
page number.
Okay, we'll list it after 5th September since he has pointed out. Okay.
SLP is already filed. also.
On the prayer of Mr. M. Ete, learned counsel for the respondent, I think,
Yes, yes.
in both the contempt petition.
Not the-
List it. We'll say after 10th of September, you know, sir, after 10th of September.
Lordship, may a particular date can be fixed.
Which one? On which date?
15th, Lordship.
Huh?
15th September. Lordship.
15th September? Okay.
Luis.
15th September. Just a minute. Yeah. Mr. Ete, learned counsel for the respondent, has pointed out that an SLP filed by whom? Filed by the state against judgment rendered in the writ appeal.
24.
Writ appeal.
24.
Comma, the violation of which order? Sorry. Okay, all right. Yes, fine. And on the prayer of Mr. 15th of September.
Blessings. Bless.
In item 21, Malut, I am appearing for the state respondent, Malut,
21.
in 20. Which is analog to item 20.
In 21, you are for?
State respondents, Malut.
21 is a contempt case.
Contempt, Malut, yes,
You are appearing for the respondent.
yes.
All right, none appears for the petitioner. Heard Mr. G. Riva,
Zero.
learned counsel for which respondent?
1 to 4, Malut.
Respondents 1 to 4 in contempt case number 2 of 2023. And Miss K. Wangmo, learned state counsel, learned government advocate, representing the state in the writ petition. Full stop. Since the learned counsel for the respondent is not present, Today, released it after 4 weeks.
Oblige.
What is this matter about?
This is my lord, revision petition directed against the impugned order dated 16/5/2023. It was passed by the appellate court, learned district and sessions. What happened, my lord, I was convicted on by order dated 7/8/2019 in a check bounce case, wherein I was imposed imprisonment for 4 months. And 52 lakhs as compensation. And that order we have put to challenge before the learned district and session judge UPA. But what happened, the appeal, it was admitted on a condition that I should deposit 20% amount. And accordingly, out of 10 lakhs 40,000, that is 20% of 52 lakhs. I could have deposited 5 lakhs 70,000. But during the pandemic time, since I was having so many problems, so I could not have deposited the rest amount of 4 lakhs 30,000. On the count of that, I have not deposited the entire amount. My appeal, it was dismissed on 16/5/2023, not on merit.
Not on merit.
Not on merit.
Okay,
Only because I have defaulted in depositing the rest amount.
all right.
So therefore,
You are challenging that order.
that is. And in fact, thereafter, after that order also, my lord, we have filed another application saying that we are ready with the remaining portion of the amount that has to be deposited. But
Okay,
then again, by order dated 26/2023, that was not allowed, saying that once we have dismissed your case on your entire appeal case, so that cannot be entered. So therefore, we are approaching this one. Since other side is also appearing, LCR can also be called for, or it can be disposed of also, because
see, criminal appeal cannot be dismissed like this, is not it? It has to be on merit.
I have a statutory right, my lord.
But proceeding under Negotiable Instrument Act, it is a quasi-criminal proceeding, something like that.
My-
Lordship, they have filed this revision petitions under section 319(7) for setting aside and quashings of the order that was passed by the session and judge.
Nearer mic, mic.
16/5/2023.
Ah,
Now, they have come before this lordship saying that their appeal was dismissed because of opportunity or that was not been heard on their part. Now, this is a case, Your Honor. This is a case of the applicant, which is under section 138 of the Negotiable Instrument Act. Now, in this act, Your Honor, if you see the session judge order, which was passed on 1/10/2019, Lordship, which is in the annexures, 2, page 13. Now, Your Honor, what happened is that, Your Honor, before that, making the submissions to the contentions of the appellant, my submission before this lordship is not that, Your Lordship, Negotiable Instrument Act 1881 was amended in the year 2018. That is Negotiable Instrument Amendment Act 2018. And in this new Amendment Act, 2 of the new sections was inserted. That is the section 143A and section 148. Now, one section 43A is which talks about the interim compensations which has to be paid at the time of the trial, that is at the stage of in the trial. And section 148 of these sections which talks about the compensations, that is of interim compensation, which the appellant has to pay at the stage of the before the at the appellate stage. Now, what happened in this case is that since they have challenged the order of the CGM, the CGM, which was passed against the appellant, and they have challenged that order before the session judge, which is in the appellate court as per the section 148 of the Negotiable Instrument Act, which says, Lordship, that is the first appellate court as per the Negotiable Instrument Act. Section 148, the power of an appellate court to order payment pending appeal against the convictions. And subsection 1, which says not that in an appeal by the drawer against the convictions under section 138, the appellate court may order the appellant to deposit a such sum which shall be a minimum of 29% of the fine or compensations awarded by the trial court. And in the subsections 2, which talks about the amount which has to be paid within the period that is of 60 days, and which may be extended 30 days, but with that 30 days extensions, a sufficient cause has to be shown by the applicant. Meaning thereby, Lordship, in this the case, when they came before the session judge UPA for filing an appeal was not being heard because unless and until 20% of the minimum awarded amount has to be deposited by the appellant. After that, during the pending of the appeal, Your Lordship, and that 20% of the minimum awarded amount was not being paid by the appellant in this case. Taking into this, a lot of chances was given to the appellant by the session judge UPA. On the next day, and in this order, 1/10/2019, if you see in this order, Your Lordship, their operations of the suspension sentence was also been extended, or it was suspended, Your Honor, for the next date. Meaning thereby, Lordship, they were given the next date, ample of opportunity they were given in this case, Lordship. Now what happened? They have sought an extensions of a period in the month of January, as well as in the month of February, as well as in the month of March, and then in the month of April, 12/4/2019, they have paid not the minimum amount as per the statutory obligation which the applicant has to pay. That is of 52 lakhs, which was being directed by the learned CGM to pay to the applicant, to the complainant. That is 52 lakhs. And if we say the 52 lakhs, out of which 29% is of 10 lakhs 49,000 has to be paid to heard his appeal by the session judge, which was not being paid by the appellant. So after giving a lot of opportunity, Lordship, by the appellant court, that I would say that the first appellant court, that is a session judge in the UPA, then 16/5/2023 was being passed, Lordship. His appeal was dismissed, Lordship, because of non-compliance of the section has been implemented in the 114A, that is to pay a 20% of the minimum awarded amount by the trial court. Now these are the, and now instead of filing, now when this was being passed, instead of filing this, Lordship, they have, instead of coming before this court, appeal order revisions, when the order 65/2013 was being passed against them, they should come before this honorable court by filing appeal of criminal. But what they did is that they have filed a restorations petition for the review of the order of 65/2033 by the same court. Now in the criminal law, Lordship, there is no any provisions where the court can review or alter its own judgment or the final order, except with the few exceptions are there. That is a clerical mistake or when there is a wrong in the arithmetical error, which is also provided in the CRPC under 316(2). So, Lordship, this case is that they have, since they have come before this honorable court, challenging of the impugned order, that is of 65/2023, which was dismissed, their appeal was not been heard in the sense. To heard his appeal, Lordship, the first and foremost, as per the provisions of the 148 of the NI Act, they have to deposit a 20% of the minimum awarded amount, and that was not being paid. And a lot of delay or tactics they have been doing, Your Lordship. And I was the one who have been suffered taking off unconsiderable time in this case now, Lordship. And that is, and also, Lordship, if I say, Lordship, there is a very clear, Your Honor, provisions is a very clear, Lordship. the first mandate which they have to heard their appeal, lordship, they have to deposit the 20% of the,
Within 60 days.
yeah, within 60 days. or
If
which-
if it is not deposited within 60 days, then what happens?
Definitely, their appeal will, that, then what happened is that lordship, they will, the session judge will order the appellant to surrender before the CGM court. And that was being passed in this order of 65 to surrender before the CGM court because of non-filling of the provisions as emphasized in the section 148 of the Negotiable Instrument Act.
That is under challenge now.
That is under challenge. And since they did not fulfill the mandate, because that is one of the basic mandate, Your Honor, and has to be fulfilled by the appellant, and that was not been fulfilled. And therefore, there was the order 65/2023, if you see in the lordship, there is a clear directions by the session judge to the appellant to direct before the CGM's court lordship for the non-compliance of the order that was being passed by the learned session judge on 1/10/2019. That is to deposit 20% of the awarded amount as emphasized in the section 148 of the Negotiable Instrument Act. So lordship, there is nothing wrong or illegal part or that has been done by the learned session judge na UPR in passing of the additional orders. He has totally complied with the provisions as required under the mandate of the section 148 of the Negotiable Instrument Act. That is my submission in this case, lordship.
If he deposits now, then what happens?
Your lordship. There is no any provisions. It says that if you deposit, it is very clear on the provision. They had deposited, Lord.
What is the status now?
Status, there is, as per the order which I have in my record, which they have filed in the petition is of 16/5/2023. As per this order, they are to surrender before the learned CGM court.
Okay.
With regard to that, well, since there was no interim order from this honorable court, we have surrendered and then we have filed appropriate application. And then learned CGM has granted us bail, granted me bail, subject to the outcome of this revision petition, which is pending before this authority. That is the status. Now, my lord, recently also one judgment by the Honorable Apex Court, wherein also for non-deposition interim amount, the cross-examination to the complainant side, that was not provided by the learned trial court. So in that case, the judgment I was looking for, in that case, Honorable Apex Court has said, for the interim amount that you have to deposit, if on default of that non-deposition of that interim amount, your statutory right to cross-examine the complainant witness cannot be granted. Likewise, in my case, since appeal is my statutory right, so only because I have not deposited.
All right. So why the record is necessary here?
Record is necessary.
Now, lordship,
For what purpose?
lordship,
See, facts are not disputed.
Facts are not disputed, but
So whether-
all the documents,
See, whether that
record is perused.
dismissal order of the appellate court for not depositing the 20%.
20% also partly you have already paid.
You is justified order or not, that is only to be determined.
That is to be determined, but then my lord, basically, this impugned order that was passed on 16/5/2023. But then appeal, it was admitted. What is the ground taken is that appeal was registered on 12/9/2019. But then in between that, my lord, there was a COVID pandemic, my lord. And maybe how many times this case it was listed. Those record, it is not reflected in this impugned judgment also. Therefore, record will be required.
Now, Lordship, in this case, I think that Mr. Counsel is confused in this regard to this provisions, Lordship. Now, the citations of which he is talking about, that is cross-examination was not given. That is, I already mentioned to my before making my submission, that is of section 143A. That is also talks about the interim compensations at the stage of a trial. And he was talking about that stage, Lordship. Whereas my case is falls under section 148. That is the power of an appellate court to order payment against the convictions, Lordship. Now, Lordship, in this case, Lordship.
Now, what has happened to some of the money he has deposited?
Whether but if you see the provision, Lordship, he has to pay 20%.
What is the status of those money?
That are deposited, I think that is
That is
not in
still
my
the-
record, because in the.
That is still in the
I don't
court.
have, I don't have any knowledge of that. I think that may be deposited in the court. Now, the issue before this honorable.
This is from UPI.
Yes, UPS.
Okay. We'll examine. We'll, after 2 weeks, since there is some urgency on your part also, you have to, you have to receive the money, is not it? So we fix a date after 2 weeks. Record, he says the record may have to be looked into. We'll request the record also, says, huh? What do you say?
LCR may be called for and matter may be fixed for listed for admission here in that case.
When do you want? But why your appeal cannot be dismissed for not depositing?
Because if
In-
interim amount that I have to deposit, in that judgment, my lord, that was that interpretation. If suppose that 20% is not deposited, what is the remedy that they have? That fine, that amount,
You
they
owe
can
a,
be recovered.
you owe a money to him or not?
No,
Huh?
I don't owe. That much of amount I don't owe. So therefore, we have filed the appeal. Ma'am.
Yes, choose earliest date. Record will also come within a week. First September.
Okay.
1st September is what?
No, no.
Friday, I suppose.
No, 1st September is a holiday. Friday. Huh? No,
Then Monday, 4 September, Monday.
For September. For September. Maybe also.
Fine, 4 September.
4th September. Okay. Had Mr. K. Tamal competition and D. Yoka, learned counsel for the respondent. Considering the urgency expressed by Ms. Yoka, learned counsel for the respondent, let this matter be enlisted on 4th September. Registry shall take steps to requisition the LCR. And place the same before the court on 4th September. Along with the revision petition. Also. List accordingly. List accordingly. List it on 4th. All right.
Highly obliged.
Yes,
My lord,
this is which item?
item number
23.
23.
Okay. Twenty-three.
Non-APS.
Tama was there? Oh, no, not Tama. Non-APS for the petitioner. Mr. J. Sri. Learned PP. We have never listed up the 4 weeks. Yes.
My lord, I'm appearing for, on behalf of RV Yadav, respondent. We need to file a reply, my lord.
Reply. You are for the respondent.
Yes, my lord.
How much time?
2 weeks.
We'll grant them 2 weeks time. Any objection?
No objection.
Okay. Miss M. Islamic Council for the petition, and your good name?
T. Darin.
T. Daring. Islamic Council appearing on behalf of Mr. R. V. Yadav. Islamic Council representing all the respondents
Yes, madam.
who prayed for and is granted for the 2 weeks time
Yes.
for filing a counter affidavit listed after 2 weeks.
Obliged.
This item number 25,
Ah.
perhaps this must be the oldest case, 2013, my lord. And I have checked the record, time and again they have taken the adjournment, my lord. My lord, this is pertaining to the Chakma rehabilitation of Changnak district, my lord, the Dam circle. Now only problem, my lord, the petitioner council is not present today.
I think Mr. Tiwari is appearing here. No?
No, my lord, some Guwahati based advocate used to appear. Okay.
All right. Well, listed over 2 weeks.
4 weeks, my lord. Yes.
Huh?
4 weeks.
None appears for the petitioner. Mr. R.S. Naval London AAG for the state. You are
Mr. Kato for central government, my lord.
H. Kohagalampo. Okay. Your good name?
Dani Dole.
Hmm?
Dani Dole. Dani Dole.
Danyi Dole. Islamic Council appearing on behalf of Mr. H. Lampo. Islamic Council representing respondents number 16 to 86.
Yes, sir.
Also in view of the non-representation, the Islamic Council for the petitioner listed after 4 weeks.
4 weeks.
Okay.
Your lordship, in this matter, the interim has been granted, so status quo to be continued.
Interim order passed till the next date of listing. Okay.
Next time, don't forget.